Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, United Kingdom. I'm looking this morning at a book which has come to us from the Federation Press in Australia. We've reviewed some of these books before because they have a very important role to play in the overall concepts of common law, which of course Australia has and has developed along its own lines, inheriting much of the basic legal principles from England. The book we're looking at today, though, is called Seddon on Deeds by Nicholas Seddon, and it's only a small book. I'll show you the book in a moment. It's only a small book, but it's very, very detailed. I found it a fascinating read, coming to this now from what is effectively a separate common law jurisdiction here in England. Now, my wife Elizabeth and I talked about the book. We thought it was very interesting to read, and we've given it the title for our review, Deeds in Perspective for International Commercial and Property Lawyers. Let's have a look at the book first. There it is. Nice little sort of gold cover, very much in keeping with colours in Australia. I hope you don't mind me saying so. There's the book itself. It's a very interesting book from a number of points of view. It's heavier than you would think. It only runs to 250 pages. Now I'm going to hide something and show you that in a minute. Here is the index at the back, which is quite detailed. Then you've got what you can see here, the standard for many legal texts and other texts, of course, paragraph numbering and footnotes. So you've got a lot of information which is pretty easy to follow. Now right at the front, inside front cover, interesting little piece of history here because you've got a deed. And that's rather interesting to see the way in which other people do it. I do like the dedication. I always mention those, which has been put there, to my grandson Byron, the great-great-great-great-grandson of William Seddon. Now, look at Seddon and you'll know who we're talking about. There is the front page, very important jurist. Then there's a foreword by the Honourable Michael Kirby, and that in fact runs through for a few pages. It sets out where we've come over the years, and again I thought there was a great deal of learning even in the basic foreword that's being published to explain where Australia is today. Then you've got the chapter headings, most of what you're looking for. There are 7 chapters and then an index you can see. So there you can see all the headings there, and it's logically structured. Then Nick Seddon has produced a very interesting preface, which starts off, "Get a life," responded some of my friends when I said I'd embarked on a legal text on deeds. Well, this is it, isn't it? I'm afraid people do have that line, but my word, what a lot of work he's put into this, and I must say I think we are very lucky that he's done so. Table of cases there. And then some statutes, of course, all of course Commonwealth, various Australia, various parts of Australia is covered, of course covered. Then an introduction there, and stating nice little quotes again, use of little quotes from the past. And then you've got, in fact, the first quote is a very interesting one from Beswick and Beswick, which I'm sure many of you will know. "I do not profess to have a full understanding of the Old English law regarding deeds." Lord Reed, very, very experienced judge, of course known to many of us in Beswick and Beswick. So that's where we start off. Very interesting. So where do we come from there in both Australia and the United Kingdom, or England and Wales? Well, this is what we say about the book, because obviously I'm looking at it from the point of view of being an English barrister at law, but I did find it a very fascinating subject area. Not that I'm an expert, of course, in deeds. I've done my qualifications and put all of that lot to one side because my general practice is common law. However, this is a very important area because it's the bedrock, of course, of much of our common law jurisdiction. So this is what we say. When exactly do you need a deed? Is a deed better than a contract, or is a contract better than a deed? Well, of course, the wisdom there will be that the deed is the best because when it's form, it's a deed, or you have the consideration concept, which was fairly unique to the English legal system. as developed in other jurisdictions. But the answer is obviously a deed is generally better because it is a formal document which is written down. So this book, published by the Federation Press, called Seddon on Deeds, is a scholarly yet down-to-earth and very practical volume, tackling these questions head-on. Specifically, it's about the law of deeds in Australia, and therefore international and comparative lawyers will almost certainly want to have a look at it, especially as Australia is such an important common law jurisdiction in the Pacific region. And I do state that is, I think, an important factor, bearing in mind how many countries have adopted the common law approach. The principal audience for this book, says Michael Kirby, writing in the foreword, will be commercial and property lawyers who need to know when the use of formalities of a deed is useful, desirable, or necessary. The short answer being not very often. And one of the reasons, of course, is cost. If you think about it, it's a bit of a pain to have to get round to do a deed, but sometimes it works. I've had international cases and I do feel a lot more confidence if I've actually got a deed in front of me, especially in other jurisdictions. I'm thinking of the United States of America in particular, but I do think it can be quite useful because it shows a clear intent. And when you're dealing with oral contracts, which I do all the time in the contentious litigation, it can be a bit of a nuisance if you haven't got anything which is much more rock solid in terms of what can be proved in court. Anyway, let's go back to the book. The author, Nick Seddon's insightful commentary and the not rather infrequent references to the common law in the manner of deeds does much to enhance the lawyer's understanding of what a deed is, why we should use it and why we shouldn't. And I think that's again a very important point to bear in mind. As the law of deeds tends to be uncertain, the author focuses on the certainties rather than the uncertainties of deeds, and therefore has chosen to describe, quote, the circumstances where the use of deeds is mandatory or customary in law, or where there may be good reasons for using them. And obviously you can see the sense of that. The book's 7 chapters cover virtually all pertinent aspects of deeds, including the continuing struggle to define the term deed, which of course is, like everything, possibly subject to a number of interpretations. Here, a quotation from the 1928 text Norton on Deeds is helpful, but not necessarily applicable in all times and places. To summarise, the book covers such matters as the use of deeds, their execution, delivery, alteration, variation, interpretation, enforcement remedies and discharge. The final chapter will certainly be of great interest, we think, in that it compares deeds with contracts and examines the legal reasons for using a deed. The conclusion here is that there aren't many circumstances where a deed must be used, and that there are also circumstances where a contract would suffice. It's a difficult one, but being a bit cautious, I would suggest if you're dealing with quite a lot of money and land, it might well be an important factor to bear in mind because of the nature of the transaction itself. But that's only a personal view. I think it's better to be safe than sorry, if I can be as blunt as that. But I know it costs, and as I say, I know it takes up quite a lot of extra time. You've got to get witnesses and all the other usual things going with it. Seddon has obviously aimed to provide a rational, factual and therefore unsentimental look at or re-examination of deeds based on a formidable amount of research and supported by frequent reference to case studies throughout. The case study list is really quite interesting. Let me conclude by saying that also of some help are these tables of cases and statutes and the handy index at the back. Not too big, not too small, just right. If you deal with deeds or plan to, then you're more probably than not going to read this book, and I advise you to. I think it's easy to read. I thought it was of a really high standard, good quality, good academic jurisprudence here as well. So thank you, Nick Seddon and Federation Press. The publication date, I believe, is cited as at March 2015. Let's have a look at the book again. Hardback, nice sort of Australian cover to the book. I did like that. I'm going back to that again. That's the inside front cover about a deed. Brings back the old days a little bit. And the quote as well of William Seddon all those years ago. Now, what we do have, just going let's go into the middle of it, the use of deeds, terminology. There we go. Again, you've got a standard structure here, numbering, the footnotes and so forth and everything else. The execution of the deed, that's where the costly and the bother bit comes in. A lot of information on that. Delivery and escrow, yes, well, alteration and variation, that's an important area as well. Because quite often, I mean, in fact, mentions a really old case, Pigott's case, which I think many of you will probably remember from some years ago when you were studying the academic side of the course. Then finally you've got, that's the course of law, then you've got the index. Well, thank you very much to Nicholas Seddon and to the publishers. It's an excellent book, I'll treasure it. Found it very interesting and different from what I'm normally looking at. If I had a book like that in this country, it'd probably be at least 5 times as heavy and rather a lot wider. Thank you anyway. Bye-bye.